For motion.
Item
Item for motion. Item number 1.
Apologize to interrupt, Lordship. I seek Lordship indulgence in mentioning one unlisted item. We had filed this appeal last Friday. It's almost a week now. It's yet to be listed. So my humble prayer is that the matter may be listed for tomorrow if possible. Only for issuing notice, madam.
Okay.
Item 1.
My Lord, I seek your indulgence in mentioning item number 6, part 2.
Don't take your time. You should do it immediately. What?
My Lord,
6, part 2.
yes, my Lord, with the consent of the other party, can this matter be taken on this last week of February?
We'll make it the February or March.
February.
No, not possible. If you want March. You're for the
Respondent.
respondent. Mention is made on behalf of Mr. B. Lalram Ega, learned standing count. Have you taken the consent
Yes, my Lord.
for adjournment of the matter? For the respondents, for adjournment of the matter with the consent from the other side. In view of above, list the matter during the second week of March 2020.
Yes, my Lord.
Yes.
Item 1.
May please, Your Lordship. My Lord, in this writ petition, we are challenging the illegal and arbitrary action of the respondent associations who, without any sanction of authority or law, took the law into their own hands and evicted us from our homes, and thereafter disallowing us to stay at our village, thereby violating our constitutional rights guaranteed under the Constitution of India.
Who's for the respondents? Anyone for the state? Okay, we'll issue notice.
My Lord, respondent number 1 to 5 are the state respondents. 6 is the 6, 7, and 8 are the respondent associations, and 9 is the village council president. And today, Lordship, I'm humbly praying for an interim relief.
No, not possible. Let them give this. Heard Mr. Aldrinzo Thanmoya, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India, praying for the issuance of the appropriate writ or order / direction to the respondents on the grounds that the petitioners were illegally and forcibly dispossessed of their residential house at which place?
Bungklang, Sersip,
At Bungkla Serchi, without any authority of law and without due process of law, thereby violating their fundamental rights guaranteed under Article 14, 19 and 21 of the Constitution. Anyway, issue notice to the respondents. Ms. Lalnundri, learned government advocate, accepts notice on behalf of the state respondents. Full stop. Notice be issued to the other to the other respondents through registered post with AD within 2 working days, returnable by, we'll make it 2 weeks, by 2 weeks, list after 2 weeks.
I'm obliged. Deeply obliged.
Item 2.
Yes.
My lord, the petition pertains to an order directing the respondent to sanction invalid pension.
Pension?
Yes, according to rules 38 and 49 of CCS Pension Rules 1972. And the read with the Government of Mizoram notification dated 7/6/2019.
Page?
The notification, you may please see, my lord. Page number 26.
26.
Yes.
Yes.
May I read? In the interest of public service, the governor is pleased to order adoption of Government of India's Office Memorandum issued by so-and-so dated 12 February 2019 and notification by number so-and-so regarding grant of invalid pension under Rule.
This annexure 8 is not eligible. Okay,
Uh,
next page, retyped, yes,
yes.
yes.
Under Rule 38 of the Central Service Pension Rules 1972. However, the rate of minimum pension mentioned in the said office memorandum and notification that is rupees 9,000 shall be substituted by rupees 8,700. The adoption shall take immediate effect.
Yes. So, what
And-
happened to him?
My lord, I was removed by the respondent authorities in the year 2016.
Where's the order? 2016?
In page number 17,
17.
Annex 3.
Okay, invalid pension.
Yes.
Because, okay, he was not well.
I beg your pardon, my lord.
He was not well. What was his?
The
Oh,
grounds
this
was
is alcohol dependency
Yes.
syndrome. Invalid pension because he was maybe an alcoholic and therefore found unfit.
Yes.
So he served for how many years?
After adjustment, my
Period of
length of
service?
service was 7 years,
7 years.
9 months.
Okay. And invalid, okay.
Actually,
And
my lord,
you will be pensionable after how many years? Entitled to get pension after service of how many years?
prior to the amendment of the pension rules, minimum qualification, the length was 10 years.
10 years.
Yes.
So you don't
But-
have the 10 years,
Yes.
7 years.
Yes. After the amendment, length of service was irrelevant.
Was?
Irrelevant. It's not being
Okay,
counted.
where
yeah.
where's the amendment? What you just read, is it? No, where's the amendment, that length of
Page number 22.
22?
Yes.
Okay. If the invalid pension, okay, because of the right of persons with disability rules,
Yes.
because of those rules, length of a service becomes irrelevant if you become disabled, is it?
Yes.
But your
there was,
nature of disability is alcohol dependency syndrome. Is that a disability under
No,
the
my lord.
the Persons with Disabilities Act? See, you're taking me to
May-
page 22, okay?
Yes.
At page 22, the length of service becomes irrelevant in view of this Rights of Persons with Disability Act, okay?
Yes.
So if they are disabled and they were healthy while they recruited,
My lord,
but due to some disability, then length of service, then,
disability is another parameters.
pardon?
Another parameters.
Okay,
It has to be looked to
okay,
the
which is
person
the
who-
other parameters?
And another one is mental infirmity. So,
So he has some medical certificate showing his
yes,
medical
there is no
infirmity.
question on medical examination. I was denied invalid pension because I have not completed 10 years.
Okay,
That is the only reason.
okay, so you're saying that it's not the it's not because he was alcoholic, but he has some other disability, and therefore can be this thing included, is it?
Yeah,
Okay.
I'm fit.
But you'll have to have the medical documents.
Medical
You have not
certificate,
enclosed
medical-
anything.
Medical examination has been conducted before I was being removed.
So where's those medical documents? You have to come with something. Otherwise, simply because have this
I could have an
alcoholic dependency, that cannot come under this thing, Disability Act or rules, isn't it? Here, this charge is because of
My lord.
alcohol dependence syndrome. Can that come under this thing?
Absolutely. Mental
Because then all alcoholics will have that excuse. They'll work for a short period. They'll drink a
was-
lot of alcohol.
I was
So,
examined.
if you're saying it's not because of this, it is some other mental disability, then it can be considered. Okay, it's just 7 years service because, so you have to have some other documents, which
My
I'm
lord,
not finding.
It was not in dispute. I was
No.
examined before.
Huh?
I was released.
Huh.
I was removed.
So this
And the competent
alcohol
authority-
dependence syndrome, this is because, this is the reason why you were this thing removed from service. So you're saying this order is wrong because it is not because of alcohol dependence syndrome, but because of something else. Is that your case?
No, the main reason is alcohol dependence syndrome.
Ah,
And it was being approved by the concerned authority where I have been engaged. I was employed.
but can you claim that the necessity of having 10 years due to the act, that is Disability Act, you are covered under that, is
No.
it? You have to convince the court. I don't think,
My lord, may I
because there's
read
so
the,
many alcoholics, yes. They
may I
cannot
read the amendment? The numbering is a bit
Page?
confusing in page number 22,
22, huh? Yes.
provided that
Rights
paragraph.
of Persons with Disability Act. Because of this, the requirement of serving for 10 years to be entitled to pension has been done away with. Okay. So, so which part do you want to read?
If a government servant, from numbering is a bit quite confusing. So, if a government servant in a case where the provision of section 20 of the Rights of Person with Disabilities
Okay,
Act
let's see section 20.
are not applicable,
Okay.
retired,
Let's see section 20 of the Rights of Persons with Disability Act. We have to see that are not applicable.
Yes.
So if that is not applicable, so what
Yes.
is 20? What is section 20? And retires from service on account of any bodily or mental
mental.
infirmity.
yes.
So you have to prove that he has retired because of some infirmity. So alcohol dependency, will that be a mental, that has to be looked into.
That-
Okay, let's look at the Disability Act, where section 20 is not applicable.
Yes.
But, so what is section 20? What does it say? Do you have any idea? No, you have no idea what it says. Then we'll have to see. You this thing, search in your, on your mobile network, is there section 20? What does it say? If this is not applicable, what is not applicable? No, 2016, this is not there. See, simply claiming you're mentally disabled because you have alcohol, then the police force, there's so many people who are having this dependency. So what is your case? How are you trying to project your case? This alcoholic dependency is also a mental infirmity or what?
Yes, my lord.
He
I
has
have
to
been
confirm.
examined.
Huh? Is there any this thing, medical this thing document enclosed? Have some medical document enclosed at least. Some letter from the doctor that he is mentally disabled. He has a mental infirmity.
My lord, may I read the office order, removal order
Yes,
in page number 17?
removal order is very clear.
Page number 17, Annex 3. See,
Alcohol dependence syndrome. Because of that, invalid pension. I know we can issue notice, but I don't know. Yes, so page 17, he is suffering from alcohol dependence syndrome. Okay.
yes,
So, and therefore, he is released from service on invalid pension
yes,
because he cannot perform. Now, invalid pension is because, so if he is released on invalid pension, as per the rules, he has to serve for at least minimum 10 years.
yes,
But he is served only for 7 years.
yes,
But invalid pension, he will still be entitled to pension if he is mentally disabled as per the act. But this sickness, alcohol dependency syndrome, can it be covered under persons with mental disability? That we have to look into. Hey, Ladi, will you show notice if you want, but I don't know whether you'll have a good case or not. Otherwise, people will take advantage of this. We have so many people in the armed force who are not able to serve, and then if they pray to be released, if they pray to be released from service after a short period and still get their pension because of their alcoholic alcohol dependence syndrome, then it will create a lot of problem. I think your writ petition deserves to be dismissed outright.
no, my lord. See, people will not misuse it.
Anyway, we'll give you the liberty to file additional affidavit at a later date to show that you come within the ambit of the act, wherein the requirement of 10 years is done away with if you are found to be mentally disabled in the meantime. Okay. You must be having some medical documents.
I can provide.
You have, but you have not enclosed them. Enclose those medical documents showing that you can come within the umbrella of this act where you don't need to complete 10 years of service. Be a little bit more convincing, isn't it? So we'll list another date and you enclose those documents, okay, to show that your mental disability, where you cannot continue to perform your work, is not solely because you are having alcoholic dependency as noted by them, but some other mental disability.
My lord,
Can you do that?
yes, I can do that.
Then you do that first.
I would like to elaborate a few points regarding disability and mental infirmity. The amendment was a bit confusing, and
You are confused. Then?
Even the Honorable Supreme Court seeks clarification,
Huh.
and I have annexed that order, the Honorable Supreme Court order, in page number 28.
Wait. What does the apex court say? Disability. So, wait, read the relevant portion.
I'll read it from page number 28 from the first page.
Yes.
In our previous order dated so and so, we had recorded that benefits as claimed have been conferred to the respondent, but a lesser question did arise in the case which was recorded in the said order in the following term. Rule 38 of the Civil Service Pension Rules so-and-so has been amended on 30/9/2016. By virtue of the amendment made, persons who suffer disabilities while in service, if given the benefit under Section 47 of the Person with Disability so-and-so Act 1995, would henceforth be governed under the provisions of Section 47 so-and-so, subject to the production of a disability certificate from the competent authority as prescribed under the Act. However, Rule 38(2), as amended, provides that if such employee to whom the provision of Section
No,
47...
there's no confusion. See, read page 30. Page 30. Okay. Page 30, here it says, provided that such employee shall produce a disability certificate from the competent authority as prescribed under the Rights of Persons of Disability Act. So we have to show, isn't it? So that has been clarified. Then the matter was listed after 3 months. After 3 months, this clarification was made.
It was made, and
So read page
in
31.
yes.
Having perused the aforesaid clarification, we are of the view that the matter now stands adequately covered. So it's covered now, that confusion in the beginning.
Yes.
It is covered now with this explanation that this certificate, mental disability certificate covered under that has to be produced. So in the beginning, no clarity, but the matter was listed again after 3 months where this confusion was cleared, isn't it? So you read page 30. This is where clearing the confusion, which you said was originally in the beginning was a bit confusing. So this central service pension rules, doing away with the requirement of 10 years, is now applicable in all eligible cases. So we have to see whether your case is eligible, and to be eligible, you need a certificate from the competent authority. Okay. Otherwise, we'll have to see. So we can give you a chance, read the judgment of the Apex Court again carefully.
May I read
Come
31,
again.
page number 31, where the clarification has been produced. In this connection, it is clarified that the condition of qualifying service of 10 years for grant of pension under Rules 49(2) of the CS Pension Rules 1972 shall not be applicable in the case of a government servant retiring on invalid pension on account of any bodily or mental infirmity.
Mental
under Rule
infirmity.
38. Accordingly, invalid pension at the rate of 50% of emoluments, so and
So
so,
you have to show
whichever
your
is-
mental infirmity. You are invalid, isn't it? So you have to show your mental infirmity. You see, because the reason why you were discharged is because you have this alcohol dependency syndrome. So maybe you will get some document showing that when a person has this alcohol dependency syndrome, they come within the ambit of this Persons with Disability Act. Okay, something like that.
My lord, I'll file an additional affidavit.
So 10 years shall not be applicable in cases of the government servant retired on invalid pension on account of any bodily or mental infirmity under Rule 38. Accordingly, invalid at the rate of 50% on an average, and whatever is more. So you have to show. 31 does not clarify your case. Anyways, we can issue notice. Let the respondent do their homework. In the meantime, you can you are permitted to file additional affidavit, if so advised, supporting, to enclose some documents to support your case.
Yes, ma'am.
Okay, yes. Heard Mr. So-and-so, learned counsel for the petitioner who has filed it instant, I think I've made all that. No application, under Article 226 of the Constitution of India for issuance of the appropriate writ or order by submitting that the petitioner was discharged from his service on 17/02/2016. Being employed under the 3rd Battalion MAP on the grounds of invalid pension, by noting that he belongs to by noting that he is suffering from, within inverted, alcohol dependence syndrome, close inverted commas, and therefore found unfit to continue in service. Full stop. The learned counsel submits that since the petitioner has been dismissed on invalid pension, he is entitled to receive his pensions in terms of
Rules 38.
In terms of Rule 38 of CCS, within brackets, pension rules, 1972, wherein the requirement of completing 10 years of service has been done away with, and the petitioner has been in service for 7 years, 9 months, and 8 days. Full stop. Is that your case? Huh? And then what else? That's it? Full stop. Issue notice to the respondents. Ms. Caroline K. Lalung accepts notice on behalf of the state respondents. Anyone else? No, ma'am. On the prayer made by the learned counsel for the, okay, no need to issue formal notice, okay? Requisite copies of the writ petition to be duly furnished to the learned government advocate. Full stop. On the prayer made by the learned counsel for the petitioner may also file an additional affidavit, if so advised, to bring on record certain documents showing the medical condition of the petitioner. Full stop. This is the matter after 3 weeks.
That's
Permission. Item 3.
Lordship, I am appearing on behalf of the respondent number 4. I have finished. I have finished the drafting. However, the same needs the signature of the district collector, Kalasit.
My lord, last chance has been given to the respondent number 4.
No mention of last chance. Signatures, so positive by next week. Okay. Yes, Ms. Zaram Sampui, you have filed. Yes, very surprising. Anyway, very good. Mr. So-and-so, learned counsel for the petitioner is present, along with Ms. Caroline K. Lalung, learned government advocate, for the state respondents, and Ms. Zairem Sangpui, learned CGC, for respondents number 1, 2, and 3. Full stop. It is seen that the respondents number 1, 2, and 3 have filed their counter affidavits, while the learned government advocate submits that the counter affidavit is at its final stage and requires this and only requires the signature of the concerned authority. In view of the above submission, the counter affidavit to be filed by the state respondents, and in view of the above, list the matter after 1 week, giving a final chance to the state respondents to file their counter affidavit, if any.
Item 4.
My lord, in
Yes.
the last court date, TCR was called for. However, the same has not been received yet.
Yes.
My lord,
Where's this thing? Has it been received till date?
as per office notes, it has not
ADR
been
received
received yet.
from, yes, it's been received.
Ah.
Received, isn't it? No, TCR is not yet received.
Not yet received, my lord. Yes.
This is which, this thing, district, Aizawl.
Yes, district I
Then it should be here. We'll issue a reminder,
my lord. And
and then we'll
in
list
the meantime, my lord,
Oh.
let the matter be admitted.
interim order to continue. Is it?
Interim order to continue, my lord.
I heard Mr. L.H. Nyanshima, learned counsel, learned senior counsel for the appellant. You want to be assisted by so-and-so,
My
learned
lord,
counsel.
Road Feliz, my lord.
And also heard Mr. So-and-so, learned counsel for the respondent. It is submitted that though TCR was called for, the same has not been received till date. In view of the above, registry to issue reminder, list the matter after 2 weeks.
My lord.
After 2 weeks.
And interim order may,
Okay, meanwhile, interim order passed earlier shall continue till the next date of listing. Yes.
and my lord, the
What?
appeal be admitted also.
I think,
My lord,
let's see previous court date.
In that case, we need,
Substantial questions of
Yeah,
law was
whether-
already
there
noted.
is-
We have already provided proposed substantial question of law, which was reflected in order dated 4/7/2025, my lord, July.
Well, let
4th
this
July.
thing, CRB, this thing, then we'll see. Status quo was maintained.
Sir, yes, my lord. Substantial question of law, proposed substantial question of law has already been provided, my lord, and the same was reflected in order dated 4/7/2025.
This thing, next date, we'll see.
My lords, no problem there.
Item 5.
Lies.
Respondents number 1 to 5. Have you filed the affidavit? Who is representing 1 to 5?
Yes, Your Lordship, I'm on behalf of
Oh, okay, government, yes.
P. Vani Syami, Your Lordship. This matter can be listed for hearing as per the instructions given to me on behalf of.
Okay, you're not filing your counter affidavit, is it? Or have you filed?
They have not filed. They have not filed. In fact, they have declined.
Declined, it appears so. Yes, so it can be listed for hearing, it appears.
Yes,
We'll
Your
listen
Lordship.
for
Lordship, I am
hearing.
for
What's the matter
respondent
about?
6 and 7.
Notice complete, all the parties are duly represented
Yes.
and counter filed by respondents 6 and 7, is it?
Yes, Lordship.
6
It
and
is
7.
filed.
You are the more concerned. So it appears that the government does not have anything much to say.
The main contender is the respondent number 6 and 7.
What is the matter about? I mean,
It's,
what is the part played by the state respondents in this?
They have been keeping the seized money in
Okay,
their
money
account.
seized.
Yes, money seized.
Foreign nationals. So the petitioners are said to be foreign nationals.
Lordship, petitioner is the proprietor of a variety store at Zokotar.
Okay,
known
okay,
as
then the
Malpur
money
Variety
was
Store.
kept with the income tax department, is it?
Yes,
Ah,
yes.
okay, okay, yes. So the state, you had seized the money, the state, and then you handed over the money to the income tax department, isn't it?
Yes, yes. That is without any
So
authority
is
of
there
law.
a case filed against you by the income tax department?
Nothing, there's nothing.
We'll have to hear. I think some case was filed against you.
They have required us to make appearance before the income
Appearance.
tax department,
Huh?
but that notice was given at a very short notice,
Huh?
and they had in fact come over to Champai, and they had taken possession of the money.
So, supposing you had appeared before the income tax department and cleared the matter.
Not in Guwahati, not in Guwahati. They had asked me to appear before the office at Guwahati.
Guwahati. Okay, we'll listen
At the
for
same
you.
time, they had come over to Champai.
Okay, so they had come over to Champai, so you
Yes.
could have gone and met them at Champai, not
Yes.
Guwahati. Isn't it? So you could have met each other and clarified the matter. Isn't it?
That's true, that's true. We had clarified everything, but in spite of that, the police had handed over the cash to the income tax department, and that too without any direction or any order from the court. Under section 457 of CRPC, the seized money in connection with any criminal case is to be under the authority of the court, and that can be kept at any place or by any other authority only with the permission of the court. That permission of the court or order of the court was not obtained. They had simply handed over.
But the CJM had made an order, isn't it?
Yes, the order is that
Dismiss the application.
while dismissing the application, it was simply stated that since the money was already handed over to the income tax department,
Oh, okay, not to you. Okay, so therefore application
it
dismissed.
was not direction for allowing them to keep the money.
Okay, we'll list it for hearing and disposal in the next court date, isn't it? So state, this thing, respondents are not going to file any affidavit.
No,
it
Your
appears.
Lordship, can be listed for hearing.
Okay, we have nothing to say, but
Yes,
okay,
Your
fine. Heard Mr. Sila Ramzawa, learned senior counsel for the petitioner, assisted by Mr. So-and-so, learned counsel. Also heard Ms. Lalnunlui,
On behalf
Learned,
of Your Lordship, DAP.
appearing on learned government advocate, who submits that the matter is handled by Ms. Vane Siami, learned government advocate. And she has been informed that the government will not be filing any counter affidavit for so. It is seen that the respondents number 6 and 7, is it? Have
6 and
already-
6 and 7.
Have already filed their counter affidavits. In view of the above, since both the parties are duly represented, matter to be listed for hearing after 2 weeks, during the first week of March 2026. Yes, you want a date?
Last week of March, Your Lordship,
First week? Or any, okay, if you don't want first week, second week?
let it be starting from 16.
Okay, then during the third week of March on, let's fix a date, since it's an outstation council, it's better for them, huh? During the third week of March on 19th, okay, 19th, 3?
9th, Lordship.
Is 9th convenient? Senior
Ninth.
council, 9th. Is it convenient for you?
Let it come up on 12th March.
Lordship, any date on Monday, because it will be convenient for my senior too.
Monday is usually inconvenient for us.
Why? You're here. See, they're going to travel on Sunday, so if you want your case to be disposed, you want the money back into your hands fast,
The
isn't
thing
it?
is,
So you
yes,
fix a quick
Your
date.
Lordship, that's true.
Then?
They've been keeping it without any interest.
So you're the petitioner, you should be the one pushing for
In
an
fact,
early
we'd like
date.
to have it within this next week.
No, not next week, March. So any date during the
Second
month.
on
Because
On a Monday, March on a Monday. So that the council, outstation council can be present, then it's easier.
all right, let it be on 16.
On 16th, as sought for on 16/03/2026.
God bless.
Item 6.
My lords, in this contempt petition, my lords, AD card has returned back. Now, my lords, I'm just wondering whether, my lords, the government councils will be appearing in this matter.
Yeah, so government is for,
My lords, the
no, you are for respondents number?
Your Lordship, we have not yet received the
No, this is the contempt petition, so you will be, in your personal
state
capacity, you will be on behalf of, there's only one respondent.
two, my lords, two.
Two respondents. So you're going to appear on behalf of which respondent, one or two? This is contempt. You cannot be appearing as a government, huh?
1 and 2, Your Lordship.
Both okay.
Yes, Your Lordship.
Mr. Jordan Romingtanga, learned counsel for the petitioner, is present along with Ms. Lalnun Lui, learned counsel for respondents number 1 and 2. Full stop. The learned counsel has prayed for time to file their show cause reply. In view of the above, list the matter after 3 weeks.
3 weeks. Obliged.
Much obliged, Your Lordship.
Item 7.
May it please Your Lordship. The AD card for the respondent number 5 and 6 have not yet returned. And my lord, if Your Lordship may kindly direct that the online postal tracking be conducted by the registry, my lord.
What's the address?
Delhi and Guwahati, it seems, my lord.
Guwahati. And the other respondents have prayed for time. Is it?
Yes,
To file
my
their
lord.
counter. Yes. Ms. Rosie Iman Lomsangi, learned counsel for the petitioner, is present along with Mrs. Mary Elkiante, learned government advocate for the state respondents number 2 and 3, and Ms. Zaram Sangpui, learned counsel for CGC for respondents number 1 and 4. Full stop. It is seen that return of service report from respondents number 5 and 6 is still awaited. Full stop. The learned counsel for the petitioner has prayed that the registry may be directed to track the may be directed to track the consignment. Is it?
Yes, my lord.
For service of notice upon the respondents number 5
5 and 6.
and 6. Accordingly, registry may do the needful and submit its report for tracking of consignment in respect of respondent number 5 and 6 by the next court date. Full stop. Meanwhile, the learned counsels for the learned government advocate and the learned CGC are to file their counter affidavits, if any. List after 3 weeks.
Yes, my lord. A blind line.
Item 8.
Lordship, there's a writ petition
Yes.
for declaring the order and decree dated 26/2/2022, passed in eviction suit number 4 of 2019, along with the order dated 30/10/2025, passed in execution case number 52 of 2020, arising out of eviction suit number 4 of 2019, seeking for declaration of such order nullity and
Eviction.
non-est. Yes,
Okay.
in
So
the
now that eviction
on the ground
order,
of fraud.
okay, now the eviction order is continued, isn't it? Interim order, saying the eviction order
Yes,
is already
yes.
allowed. So what about the others?
I'm ready. We can have the hearing now if possible, my lord.
So in the writ petition, have you filed your counter?
Yes, my lord.
Lordship,
Okay.
what they have filed is written objection. Written objection. They have not filed the counter affidavit as such.
Written
Yeah.
objection to the IA, is it?
They're supposed to file written objection to the IA, but
IA is a caveat application for someone to be there, is it?
That is my application, my lord.
Caveat. So this, then this will be allowed, you already there disposed of, isn't it?
Yes, my lord.
there's a direction to the respondents, respondent number 5, to file
Counter affidavit.
counter affidavit.
Oh,
No, I
so
filed a
have you
counter affidavit, my lord.
Pardon?
I've already filed a counter affidavit.
Okay, counter, written objection, counter, okay, he's filed, he says
Yes.
he's filed, so leave it, whatever he has filed, that is his response.
Yes, my lord.
Then what about the government? Is the government a party?
Yes, the
Government
government
is
is the
the
party,
party.
but they're not filing anything, my lord.
They're not filing?
They're not-
So matter, pleadings complete?
Yes, my lord.
We can list the matter for admission hearing in the next court date, isn't it? So he says he's filed his counter affidavit, so it must be there somewhere. Have you received a copy?
Yes, my lord, I've got a copy.
Copy is there, yes.
Oh, then, heard Mr. Sila Ramzava, Learned Senior Counsel for the petition, assisted by Mr. So-and-so, Learned Counsel, full stop. Also heard Mr.
Sangzola.
Sangzola, Learned Counsel for respondent number 5, and Ms. Dalnun Lui, Learned Government Advocate for respondents number 1 to 4. Full stop. The Learned Government Advocate submits that the state respondents will not be filing any counter affidavit. Full stop. In view of the above, it is seen that pleadings are complete. Matter to be listed for admission hearing after
Next week, if possible, because there's some urgency.
will be the thing, will make it during the first week, okay, during the first week of March.
Lordship, first week of March will be inconvenient for me.
Why, you're going out of station?
I have some other engagement.
Last week of February, if possible, then.
See, if it needs intensive hearing and all that, I'm not inclined to take
It
up
may
the
be
matter.
within the second week.
But if we can be admitted and listed for hearing, then it's a different matter. Then listing for hearing will post it during, make it second week of,
Second week of March.
because if it can be disposed of at the admission hearing stage, it's good,
Yes,
isn't
my lord.
it?
Yes, my lord.
Listed for admission hearing during the second week of March.
9th March, then. Time, 10th. A date.
Let it be 10.
Okay,
That's
listed for admission hearing on 10/03/2026, wherein since the Learned Counsel for the private respondent has expressed urgency an attempt may be made to dispose of the matter at the admission hearing itself. Yes.
In the meantime, Lordship, the
In the meantime, interim order passed earlier shall continue till the next date of listing.
Item 9.
I'm for respondent number 6. My drafted affidavit not yet returned from the vetting authority. I may be granted 2 weeks' time for filing my affidavit.
2 weeks.
Yes, my lord.
Okay, Ms. Cecile Hamzawa, learned senior counsel for the petitioner is present along with Ms. Aram Sangpui, learned CGC for respondents number 6 and Ms. Lalnun Lui, learned government advocate for the state respondents number 1 to 5. The learned CDC submits that the approval of the draft affidavit is still awaited and prayed for another 2 weeks' time. Good stop. In view of the above, matter be listed after 2 weeks.
No.
Item 10.
Please, Your Lordship. My Lord, in this case, due to inadvertence on our part, Your Lordship, we had failed to furnish a copy of the appeal memo to the respondents. We will furnish them a copy within either the course of the day or tomorrow.
Okay. Heard Mr. Adolfo Coma, learned counsel for the appellant, who submits that they will be furnishing copy of the appeal memo to the respondents before the next court date. Then full stop, Miss so-and-so appears on behalf of the sole respondent. In view of the above submission, this is the matter after 2 weeks.
2 weeks. Obliged.
Obliged, my lord.
For orders. Item 11.
Is
Yes.
the case where Lordship had stated something about personal difficulties,
Take up,
which
take up the matter, it's okay, next date. Isn't it? We'll list for another date.
I'll be appearing for respondent number 3, madam.
Okay, who is respondent number 3?
He's the grandson of the deceased, the testator.
Okay, respondent number 3. Okay, and who's for respondent number 1?
Lord, I am for the
and is Laldin Puya, who is now arrayed as
Who
respondent.
died, huh?
And during the course of the proceeding of the appropriate case, Laldin Puya died, and he was shot to be represented by three persons.
The sister of the deceased
Sister.
and the son of the deceased. The sisters of the deceased.
Sister and the son of the sister of the deceased, and
Anyways. So we list another date. Mrs. Sheila Ramzawa, learned senior counsel for the appellant is present along with Mr. So-and-so, learned counsel for respondent number
1 and 2, my lord.
this is Rokuma Pauto is for respondent number
Respondent number 3.
3 and Mr.
Arnold Woodfellow, my lord.
Alal Rothfeller
One
for
and two.
respondent number
1 and 2, my lord.
1 and 2. Good start. Then TCR will be required. It is seen that all the parties are duly represented. TCR required or not? In this case,
I think it's required.
TCR to be called for. List the matter after 2 weeks.
Yeah.
Item 12. Lordship, this is a criminal revision petition. And by filing this petition, there is a delay of 113 days, 113 days, Lordship, against the impugned bail order, Lordship.
Bail order?
Bail order, Lordship, yes.
What's wrong with the bail order?
Lordship, there are as many as 7 grounds for releasing of both the respondents, Lordship.
Bail was granted or not
Bail
granted?
was granted. So I'm for the Union of India special
So,
PP. So we are challenging the bail order, Lordship.
Okay, you are challenging the
Bail
okay,
order.
Yes, bail. Order granting bail, isn't
Yes,
it?
Lordship.
Heard Mr. Jonathan L. Towson.
Johnny L. Towson.
Johnny L. Towson, learned counsel for the petitioner who has filed the instant IA under Section 5 of the Limitation Act for condoning a delay of 113 days in filing a criminal revision petition against the bail order dated 16/07/2025 passed by the Special Judge NDNPS Act, ISOL in bail application number 158/2025. Issue notice to the respondent one. Is it the respondent? Through register.
Yes, there are 2 respondents, Lordship. 1 and 2. 2 respondents.
Okay, to the respondents through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks. Yes.
Supply, Lordship.
Item 30.
May it please your lordship. As my lord, this application is filed under section 151 of CPC 1908 for disbursing the half of the amount of compensation. Rupees 70 lakhs 80,119, that which was deposited to the executing court by the Honorable Court Order dated 28/10/2025.
Okay, we'll issue notice. Any objection to that? Money is there.
My Lord, let notice be issued to the department because I have to be engaged separately for each and every case.
Yes, heard Mr. PC.
PC Dalthammoy.
Dalthammoy, learned counsel for the applicant who has filed the instant application under section 151 of the Code of Civil Procedure for releasing/dispersing half of the compensation amount of rupees 70 lakhs 80,190. 70 lakhs. That is the amount of rupees 35 lakhs 40,059 in respect of the not in respect, arising out of the connected RFA number 49/2025, which arising out of execution petition number 3/2025 in LA case number 18/2025, wherein the said money is already deposited into the executing court, that is fast track court - additional district and sessions judge, Colosseum, by the concerned respondents in connection with this court's order dated 28/10/2025. In what? Guwahati High Court dated 28/10/2025. In what? There must be a case filed. I'm just looking at the synopsis. Guwahati High Court's order must be in connection with some WPC or something. Is it there? Where's the order? Order passed by the Guwahati High Court in what? In what?
In IAS Civil 191/2025.
And where's that?
Page number 48.
You should mention that also. You shouldn't have just an NIA. Page number?
Page number 48.
48.
48.
NIA Civil 191/2025. Full stop. Then issue notice to the respondents. Yes, so for example, are you going to receive notice, Mr.
I may not receive now, my lord.
Then you sit down. I'm thinking issue notice to the respondents through registered post with AD within 2 working days, returnable by 3 weeks. List after 3 weeks.
Item 14.
Yes. My lord.
Similar order?
Yes, similar order.
Similar
But the amount
order?
is different. Amount is different.
Okay. So what is the amount?
Here the amount is 31 lakhs rupees, 31 lakhs, 26,726.
Okay. The amount is different and half of that will be 15. So I think if we just look at the synopsis, everything is clear.
Yes.
Okay, so same order, issue notice. Only thing is the amount will be different, RFA will be different, execution case number will be different. Is it? What about the LA case?
LA case number is also different.
It's also different. Okay, LA case will be different. The court will be the same. Then the Guwahati High Court order will
Order
be
is same. 2810 is same.
okay. In IA, the IA will be the same or different?
The IA is different, my lord.
But you have not mentioned the IA, so every time you have to look. So you simply mentioned the Guwahati High Court order dated 28/10/2025. In what? IA number?
IA number 192. IA Civil 192/2025.
This will be 192. Okay, the previous one was 191. This will be 192/2025. Okay, yes.
Obliged.
Items 15 and 16.
Lordship, this is an application for substitution of the legal representative, next friend of the minor, Gracie Larin Sangi, daughter of Sila Lompuya. During the earlier proceeding before the MSCT for claim of compensation due to death of her father, the minor was represented by C. Zonun Pui, the paternal aunt of the minor. And she has been shown to be living with them, but she has not been living with them after death of the deceased, that is father of the minor. And even during the lifetime of the minor, the deceased, the minor and the applicant, they were living separately from the house of the deceased. Because though they were married, the applicant and the deceased were married, because of personal difficulties, some personal reasons, they lived separately. And there was no legal separation as such.
Then we'll have to issue notice to the previous, who was representing? C. Zonun Pui. She
Yes.
was the one who was there in McApee previously.
Lordship, I am representing C. Zonin.
So any distinct objection to that?
Actually, I have not received, my lord, a copy of the petition.
Okay, then we'll issue notice if Zone Nunpui does not have any objection, then it can be disposed of straight away by allowing the change in the representation, the representative, isn't it?
Yes.
Of the minor. But since no instructions have been received yet, will issue notice. Heard Mr. Serial Ramzawa, Learned Senior Counsel, assisted by Mr. So-and-so, Learned Counsel. This is application filed under Order 32, Rule 4 and 9 CPC for implement of Srimati Lalmuan Kimi, mother and legal guardian of Gracie Lalrinsangi, within brackets, respondent, within brackets, minor, okay, close bracket, respondent number 1, in MAC appeal number 10 of 2025, as the next friend slash legal representative of the minor in place of Srimati C. Zonunpui, who was the legal representative of the minor child, Gracie Lalrinsangi, within brackets, minor, respondent number 1. Full stop. Notice be issued to the respondents. Mr. Mizoram Chana, Learned Counsel, accepts notice on behalf of Srimati C. Lalnunpui, Zonunpui, who was arrayed as the legal representative of the minor Gracie Lalrinsangi, respondent number 1. Stop. The Learned Counsel submits that. Issue notice and accepts, accepts notice on behalf of so-and-so, that you have said, is there. While Mr. So-and-so accepts notice on behalf of Benjamin so-and-so, accepts notice on behalf of respondent number 4. Who are the other respondents?
Number 2 is the owner of the accident bus, and the number 3 is the driver.
Okay, I don't think
They are not
notice need to
contesting,
be
madam.
heard. It is submitted at the bar that the respondents number 2 and 3, is it, are not contesting the instant MAC appeal.
My lord, may I interrupt? On the last court's question, the notice was issued with regard to the main appeal in regard to respondent
it
number
is
2 and 3.
submitted at the bar that the instant IA, okay. In the instant IA, the respondents number 2 and 3 are just pro forma respondents, and notice need not be issued to them. Full stop. In view above submission, since notice is received on behalf of respondents number 1 and 2, requirement for issuance of notice to respondents number, who are they? 3 and 4, is it? The driver and
2 and 3.
2 and 3 stands waived. The Learned Counsel for the Learned Counsel for Srimati C. Lalnunpui, Zonunpui, submits that he may be given time to receive instructions in that matter, in this matter. In view of the above, list the matter after 2 weeks.
3 weeks.
Okay, 3 weeks. It's basically this, yes, Zonunpui who has something to say in this matter, isn't it? I don't think.
I was, yes, the representative throughout the whole trial during MSC
So let's see
tribunal.
how, if you are going to fight to
It's
represent the
only
minor
after
child.
money has come that this
money.
issue has happened.
So now respondent number 4, is it?
My lord.
Are you going to file any this thing?
No.
with your- Okay. Instructions, while the Learned Counsel for respondent number 4 submits that they will not be filing any written objection to the said IA. Okay. Then, in view of the above, this after 3 days.
Obligation.
Part 2, item number 8.
Hearing. and
Yes,
mat-
Lordship,
wha-
this
what's
is
the
the-
matter? Is it simple? It is on the quantum or what?
Lordship, this is, this appeal is against the dismissal judgment and order passed by the learned tribunal. If your
Okay, why
Lordship,
was it dismissed?
which is at Lordship, page K, dismissal order is at page K. There are two grounds of dismissal reason. Number one is the insurance policy submitted by the claimants before the tribunal was not valid. I mean, like, that was at the time of the accident, the insurance policy was not valid.
Okay.
And the second one is the claimant did not produce any document to show that the deceased died due to the vehicular accident. So on these two grounds,
So
it
let's see
was-
the policy. Was it valid?
Lordship, the policy at the time of the accident, it was not covered. That policy was after the said accident. It was annexed in the claim
Then-
petition, Lordship.
Good grounds for dismissal.
Then, Lordship, the owner is also arrayed as the respondent, Lordship. If the insurance policy is not valid, and that is the responsibility of the owner of the accident vehicle.
Owner
Lordship.
was made a party.
Yes, he was made a party, Lordship.
Did he appear?
No, Lordship, he didn't appear. He has received the this notice, but he didn't turn up. And our main grounds is that it cannot
We'll
be.
fix a short date. It's a simple matter.
All right.
Both of you be present. But simply saying it's a simple matter, it
Yes, we have
still
two
needs a
additional
long
items.
reasoned order.
No, it's not.
And I still have one CAV to complete.
That's
So
it,
I
yes.
think I'll not
No
burden,
problem, no.
Okay. Mr. Johnny L. Tochong, Learned Counsel for the appellant is present, along with Mr. Roshan Subedi, Learned Counsel for the respondent.
2.
Number 2.
Two.
So 2, are you the owner?
I am the insurance company which was arrayed as a party in the trial court.
Respondent number 2. Then respondent number 1 is very important.
One is
very
important,
important,
very
yes.
important.
So
All liability will be fastened
what,
to
what
the
is the notice issued?
Yes, we have.
Was it received? Let me see.
Yes, we had a long proceeding earlier, and then
Issue notice has returned
Notice
unserved.
completed.
With
Oh,
return to
return
the
unserved.
sender unserved. This is 2024. Unserved notice. Return to the
Steps taken again.
unserved. So what about notice? I think at
the
least
notice,
newspaper
the order
application,
dated 23.
13/12/2025,
24.
2024 says, return to sender refused by addressee.
Refused.
Okay, refused.
Refuse also.
Complete. Okay, then we'll have to list it for hearing. On the, since none appeared for the respondent number 3. No, cancel that, okay. So, the submission made by the learned counsels for both the parties is the matter again during the first week of March 2026.